Hello, good afternoon, and a very warm welcome to everyone attending this afternoon's webinar. My name is Philip Hoddell, and I'm the chairman here at Burkitt Long. I'm delighted to see so many people wanting to attend today. As you may be aware, Burkitt Long are running a series of Wednesday webinars on a variety of legal topics. In the coming weeks, we'll be looking at an introduction to military law and also presenting employment law and construction law updates. If any of these are of any interest to you, please do book your place by going to www.burkittlong.co.uk/events. Today's webinar is entitled Send Parents and Divorce, What You Need to Know. Our presenters will be Kimberley Hircock, a solicitor in the education team, and Karen Johnson, a Senior Associate Solicitor in the Divorce and Family team. Kimberley and Karen will be looking at the legal issues, as well as providing you with some top tips, and of course, taking any questions that there may be at the end of their talk. I hope it's going to be a fascinating presentation, and without any further ado, I will hand you over first to Kimberley.
Fabulous. Thank you, Philip, for that lovely introduction, and thank you all for joining us today for our Wednesday webinar, which, as Philip has said, is on Send Parents and Divorce and what you need to know. So as an introduction, I'm Kimberley Hircock, and just to give you a bit of context about myself, I am an education solicitor, and I advise on a wide range of issues which can occur in the sector, ranging from admission queries, exclusion queries, and a significant amount of my work tends to be around advising issues relating to special educational needs pupils. I qualified as a solicitor in 2018, but before that I was a paralegal and a trainee solicitor, which had a very heavy focus on education law. So in fact, although I qualified in 2018, I've actually been in this area since 2015, and I have seen the impact and the changes which has occurred in this area, namely the introduction of the Children and Families Act 2014, which is the most recent piece of legislation to impact this area. In terms of Burkitt Long, I joined the firm in April 22. Before that, I had experiences working in a legal aid firm and I've advised 2 local authorities. Overall, I think this has given me experience in relation to what's going on in this area, including pressures and challenges faced by both the local authority, but most importantly, parents, and the challenges that have been faced. And I will now hand it over to Karen just to have her introduction.
Thank you ever so much, Kimberley. So just a little bit more about myself. I am a Senior Associate Family Law Solicitor in the firm. I qualified far longer ago than I would care to admit, in 2002. I am a resolution accredited specialist, and that means that I do specialise in relation to financial aspects in relation to divorce and also domestic abuse issues, but I deal with all aspects of family law, so divorce, finances, arrangements for children, as well as domestic abuse, prenuptial agreements, postnuptial agreements, and everything in between. Now, in terms of the issues that we're going to be discussing today, I also have some personal experiences that I'm able to bring to the table, in that I am a parent as well, and I am a parent to 2 children who have additional needs themselves. My son is diagnosed as autistic, and I have a 17-year-old daughter who has sensory processing disorder as well. So when it comes to dealing with children who have additional needs, I do have some understanding as to many of the challenges that you will all be facing yourselves. Now, as to the issues that we are going to be discussing today, if you could change the slide, please. So we're going to be looking at things such as parental responsibility, the role of the SEN tribunal, child arrangements, and other orders that the court is able to make, such as specific issue orders, prohibited steps orders, the approach that the family courts take, and also financial issues that can arise in relation to divorce. We're also hoping to give you our top tips and resources, as well as look at why, if you do need some help, we would consider that Burkitt Long are excellently placed to help you. There's also going to be an opportunity to ask some questions, and you'll also have the details so that you can get in touch with us. Now, it is important to point out that the information that we are providing in this presentation is for general purposes only. It doesn't constitute legal advice. Very much in this area, the legal position is very much focused on your particular circumstances. The information that we are providing, though, is correct as at today's date, but it is subject to changes that might come into force as a result of legislation or court judgments. Could you change the slide? Kimberley, if I can pass over. No, actually, it's me still, sorry. So we just wanted to focus on what some of the challenges it is to be a parent to children with additional needs. I can say from personal experience, it is tough. There is a constant need to advocate for your child. We have to manage issues as they arise, such as behaviours, and that is often on an emergency basis. We, as parents, have to coordinate school meetings, work and medical appointments. Could you change the slide, please? Now, ideally, these are all responsibilities that would be shared between the parents in order to lessen that load. That is difficult even in a happy relationship, and if separated, it becomes all the more difficult. Now, one of the important things and where everything starts when we're looking at making decisions and parenting children is the matter of parental responsibility. Now, that is a legal term that is used to describe the rights and responsibilities that you have as parents to make decisions on behalf of a child. That includes important things such as where a child lives, the time that they spend with each parent, where they go to school, consenting to medical treatment. Now, ideally, these are issues that will be agreed between parents, either through direct discussions, but if necessary, mediation can be used, or we can, as solicitors, negotiate on your behalf. But in default of agreement, either parent can make an application to the family courts for an order. Could you change the slide, please?
Okay. So in terms of an educational perspective, I just wanted to flag that the same legal test applies. So with the SEN tribunal, they would still apply the definition set out in the Children Act 1989, which, as Karen just described, is all the duties, rights and powers and responsibilities allocated. There is, however, a slight difference in that the education in education law, there is a more flexible and wider approach to the definition as to what a parent constitutes. So the relevant statute here is section 576 of the Education Act 1996, which states that unless the context otherwise requires, parent in relation to a child or young person includes any person who is not a parent of the child, but who has parental responsibility for them or who has care of them. So essentially what that means is that for educational matters, a parent can include a wider range of people, which can include siblings, aunts, nieces, nephew. The key here is that they have to have care of that child. Next slide, please. So here we're looking at what happens when there is a dispute between parents and the local authority in relation to a special educational needs child's education. When a dispute arises between parents and the local authority, it may be that the Special Educational Needs Tribunal, which is a dedicated independent body from the local authority, may be able to resolve disputes and make a determination which the local authority will have to follow. So the SEN tribunal usually consists of one judge and one or two specialist members who their role is to advise the SEN tribunal judge. The specialist members will come from a variety of backgrounds. They could have had experience from being teachers, being health professionals, but they would have had to have gone through a rigorous process to be able to sit on a panel, and will have high expertise in the area. As I've said, I've been in this area for law for a few years, and it has shown me that it has been a challenge for parents, and it can feel like a constant battle of trying to receive communication from the local authority, and often there's incidents of irrational decision making. And this can be seen in the continued increasing number of SEN tribunal appeals which are being heard at the SEN tribunal. I've given in this slide an example of the academic year of 2021 and 2022, where 11,000 appeals were lodged, which was an increase of 29% compared to the year prior. And back in 2014, when there was only 4,108 appeals. So unfortunately, this is still increasing, and there has also been an increase in the amount of complaints being seen by the local government social care ombudsman. So the local government ombudsman is a body which looks at complaints made to the local authority, and as you can see that from this slide, this is also being increased, with 77% of those investigations being upheld. Usually this is all down to a lack of funding in this area. There has been an increased media awareness of the Special Educational Needs Tribunal and also the difficulties parents are facing with these issues, but there's a long way to go. Next slide, please. So looking at the SEN Tribunal, and the role of the SEN Tribunal, the SEN is very limited in what it can consider and determine, and only has jurisdiction on certain appeals. And those appeals relate to where a local authority has refused to assess a child or young person's educational, health and care needs. An EHCP needs assessment is essentially an assessment of a child or young person's educational needs and looks to see whether they require support by way of an educational healthcare plan. An education healthcare plan is a legally binding document binding the local authority and should set out what the child's needs are, what provisions are required for those needs, and the outcomes that are being sought to be achieved. This assessment is meant to be a holistic assessment between different sectors. So essentially, the education sector, health and social care, and it's meant to be collated in this legally binding document. And so in order to get that plan, you'd need to have an assessment. If the local authority refuses to complete that assessment, that's where the tribunal can look to see whether an assessment's required, whether there needs to be a reassessment. If there has already been an assessment, the tribunal can look at whether there is a need to issue an EHCP, because it may be that the local authority has completed the assessment but determined that it's not necessary. If that's the situation, parents have the right of appeal to the SEND tribunal to dispute that decision. And also the SEND tribunal can look at what is stated within the EHCP, so the contents of the EHCP. Parents are also entitled to appeal a decision where the local authority has decided that it's no longer going to maintain the EHCP, because education and healthcare plans can go up to potentially until a child or young person is aged 25. So there's yearly reviews, and it could be that a child and young person has a plan in place and the local authority believes that it's no longer necessary. If that was to be a decision and it's been challenged, that can also be looked at the SEND tribunal. So there, although it is restricted in its jurisdiction, there is still a lot of areas that the SEND tribunal can come to a determination. As a side discussion, the SEND tribunal can also look at discrimination, particularly disability discrimination, and this would be looking at schools and local authorities, but I won't be covering that in this webinar. Since 2018, the role of the SEND tribunal has been looked a bit more widely. There was a trial run where the SEND tribunal was given powers to look at what social care should be providing and to make recommendations. So rather than legally binding determinations, they could make comments which would be essentially should be complied with, but they're not legally binding. This trial has ended, but because it was very successful, the SEND tribunal continues to have that power to make recommendations on what a child's health and social care needs should be listed as, and what provisions required. So just to be very clear here, in this context of SEND and divorce and family proceedings, the SEND tribunal does not have jurisdiction to look at conflicts when the issues relate to between parents themselves, for example, where a child's going to live or how often they're going to have contact with a parent, and that's the remit of a family courts, and Karen will be discussing that later in this webinar. So whilst the SEND tribunal is not able to order a decision about where a child should live or the contact with a parent, they may consider these family court findings as part of the issues that they have at hand. For example, a child arrangements order may be relevant to answering the question as to where a young person's suitable school may be, as that information within that order will say which local authority has the responsibility and where the child's main residence is. Finally, on this slide, I've mentioned about the administrative court. So this is separate from the SEND tribunal and is part of the High Court. This is where this court can be involved in educational matters when, for example, there's a dispute arising from the local authority failing to implement the provision in an EHCP. Because the SEND tribunal does not have that jurisdiction, there is this avenue of redress by the administrative court. or if there is a failure by the local authority to provide suitable education. And this is not open at the Senior Tribunal. The administrative court will get involved. Next slide, please. So the Senior Tribunal's ultimate overriding objective is to deal with cases fairly and justly. There are tribunal procedure rules in place which provide factors which should be considered when it comes to ensuring cases are dealt with fairly and justly, and ensuring that essentially they're being dealt with proportionately in line with the importance of their complexity. For example, if the matter is more complex, the tribunal should consider whether, for example, it should list a 2-day hearing rather than a 1-day hearing, or if the nature of the issue is so complex, whether there's a need for an oral hearing if it's been listed as a paper hearing. The tribunal must also avoid unnecessary formality and must seek to be flexible when it comes to proceedings. The tribunal must ensure that parties are fully able to participate. For example, if the local authority or parent acts unreasonably or fails to respond to a tribunal direction, the tribunal may consider using its powers to bar that party from further participation in the proceedings. The Senior Tribunal must also use their special expertise to ensure that they have all the information available to them to make a decision. They must avoid delay, but also balance that with ensuring that the case is properly considered. For example, they must consider whether postponing a hearing will cause unnecessary harm or whether it will assist obtaining information that may be required. So Senior Tribunals are meant to be inquisitorial, so they're meant to be looking at documents and looking at what the child's needs are rather than being adversarial, and it's more of an investigation essentially as to what's required. Next slide, please. So the Senior Tribunal have a wide range of case management powers available to them to ensure that they comply with this overriding objective of ensuring that a case is dealt with fairly and justly. These powers that are available to the Senior Tribunal include they can extend or shorten a time for complying with their directions. They can merge 2 hearings together. So if, for example, there's 2 children, you have 2 children with exactly the same circumstance, a tribunal judge can hear both cases at the same time. The tribunal can permit or require a party to amend a document. So essentially, that's the power to make amendments to an EHCP, or for a party to provide certain evidence that may help the tribunal come to a decision. They can deal with issues as a preliminary issue. For example, if there's going to be a delay in certain information being provided to the tribunal, they can deal with that at the start to see if, for example, the hearing needs to be postponed. They can, and as I've said there, can adjourn the hearing if needed and require the local authority to provide a bundle for the hearing. So next slide, please. Okay, so as I've mentioned before, the Senior Tribunal does not have jurisdiction to make an order, a child arrangements order, where you'd be looking at where the contact and arrangements in that regard, or, for example, preventing a certain parent from doing X and Y. But essentially, what would happen if there's a conflict between what the family court says in terms of, for example, if they made an order about a school, and what would happen in terms of if there was a right of appeal to the Sen Tribunal. Well, this was actually considered in X County and DW and others, and essentially it looked at the respective functions of the family courts and the Sen Tribunal. And just to give you a bit of a background to this case, it involved a 10-year-old boy who had been assessed by the local authority as having special educational needs. The local authority had made a statement of special educational needs, which is essentially the predecessor to the EHCP. The local authority had identified a particular special school that that child should attend. His parents disagreed strongly with this assessment and decided to educate the child at home. Meanwhile, there was an issue in the family courts where a family court judge made an interim care order stating that the child should be educated at the named school of what the local authority had proposed. So this case was looking at what would happen if the boy's parents were to exercise their right of appeal to the Sen Tribunal, and what would happen if the Sen Tribunal were to agree, for example, with the parents in terms of a different school placement, which would be conflicted with what had been approved by the family court. And the judge in this case summarised the situation to be as followed. Deciding where a child should go to school is an aspect of parental responsibility. Where the family court has made either an interim or a final care order, parental responsibility is shared with the local authority. Ultimately, in that situation, it is for the local authority and not for the parent to decide where a child in care should go to school, although a parent can still exercise their right of appeal to the tribunal. So a parent can decide where a child is to go to school only in the sense that they are deciding between two or more schools, each of which is willing to accept that child as a pupil. A parent is not able to compel a school to accept a pupil for any reason if it's unwilling to admit, nor can a local authority or the family court be in a better position to compel that school. But essentially, any dispute as to what the education authority does with exercising its powers is a public law matter to be determined by reference not to the principles of family law, but to the principles of substantive public law, so which is applied by the administrative court. So essentially what it's saying is that it's because the family court and Sen Tribunal are so similar, there's no reason to jump too readily to the conclusion that they'll come to different conclusions. If there is a conflict and a problem, it becomes a matter of public law, which has essentially that their decision is so unreasonable or a breach of a substantive law. So the family court cannot dictate to a Sen Tribunal how it's to determine an appeal, and likewise the Sen Tribunal can not necessarily disregard the views expressed by the family court, because there is a risk that the Sen Tribunal could be challenged by this public law review at the administrative court. So essentially, this is a bit sort of a theoretical impasse, and again, it's essentially more of a theoretical debate at this current time. Next slide, please.
Thank you so much, Kimberley. So we come to a situation where we need to consider what to do in the event that the parents are unable to agree, what the decisions are that need to be made in relation to the children. Now, as I said earlier, ideally the parents would be able to reach an agreement in relation to these things. However, if that is not possible, then it is open to either parent, and I should add that this is irrespective as to whether or not the parents have parental responsibility. All parents have the ability to make an application to the court as of right, and in this respect the court has a number of orders that is available to it to make for the benefit of the child. Now, the first one to consider is something called a child arrangements order. So a child arrangements order refers to the practical care arrangements for a child. Under the old terminology, you might have heard of it called contact and residence. Going back further in time, custody control. Ultimately, a child arrangements order deals with where the children shall live and how much time they will spend with each parent. Now, when looking at the arrangements for the children, there is no hard and fast rules as to what arrangements should be put in place. There is a presumption that it's in the children's best interest to spend regular and consistent time with both parents so long as it is safe. Could you change slides, please? Now, another type of order that is available to the court is something called a specific issue order. Now, a specific issue order is determining, as the name might suggest, a particular issue. Now, that might be which school the children should attend. It might be questions with regards to medical treatment, vaccinations, that type of thing. And another issue that could be addressed would be other interventions, and that might be disagreements between parents as to what should be in an EHCP. Could you change slide, please? Now, the last type of order that the court can consider in this context would be something called a prohibited steps order. Now, that prevents the parents from acting in a particular way. It might prevent the administration of medical treatment or prevent removal from school or removal from the country. So that again is very flexible in terms of addressing the mischief that is causing problems. Could you change slides, please? Now, when the court is asked to make any of those orders, they will always base their decision upon what is in the child's best interests. Now, in order to determine that, they have to have regard to something called a welfare checklist. Now, this includes factors such as the child's wishes and feelings, so insofar as these can be taken into account in light of their age and understanding, the child's needs, the parent's ability to meet those needs, the risk of harm and the effect of any change in circumstances. Now, one of the important things that I do want to highlight with regards to those factors is that when we're considering the child's wishes and feelings, it does not mean that it is the child's decision. It just means that their views should be taken into account. And of course, if you do have a child that has additional needs, that may have an impact in terms of their understanding, and that will also be relevant. Can you change slides, please? Now, key points to bear in mind is that, as Kimberley has already referred to, the family court powers cannot force the local authority or a school to make placement or funding or other provision available. That is the role of the SEN tribunal or the administrative court. The family court role is very much to resolve disputes between parents. Now, if we are focusing on children who have additional needs, their needs, the parents' ability to meet those needs, the risk of harm are likely to be key considerations in determining what is in the children's best interests. Could you change? Now, the other issue that will generally always need to be addressed when we are considering divorce and separation is the financial impact. Now, the rules that apply are very different depending upon whether you are married and getting divorced, or whether you are not married and are separating. Now, looking first at the situation in the event that you are married and getting divorced, the court has a wide range of powers that are available to it. All assets are taken into account, whether they are jointly or solely owned, and the starting point is an equal division of the matrimonial assets. But the court isn't constrained by that, and there is a need for a fair outcome in taking into account all the circumstances of the case. Now, the court has a wide range of orders available to it. The orders include things such as spousal maintenance, lump sums, pension sharing orders, and pension earmarking. The court can also make property adjustment orders that might require either an adjustment of the interest or a transfer of property, and that can be in favour of a spouse, but it can also be made for the benefit of children in certain circumstances. The court also is able to order for property to be sold, can also order child maintenance in certain circumstances. There are restrictions on that, which we will discuss, and can also make orders for lump sums for the benefit of child. Again, this is subject to various restrictions. Now, when we are looking at the finances on divorce, the focus is on the matrimonial assets. Now, matrimonial assets are those assets that have been built up during the course of the marriage, again, whether they are held jointly or in either spouse's sole name. It also includes assets which by their nature are matrimonial, such as the home. Now, non-matrimonial assets would be assets that have been built up either prior to the marriage or post-separation, or assets that have been received from sources outside of the marriage by gift to one spouse or through inheritance. It is important to bear in mind, though, that if those non-marital assets have been what we call intermingled, so for example, if an inheritance has been received and it's been used to pay towards the purchase of a matrimonial home, it gets far more complicated. Now, where we are able to identify that there are non-matrimonial assets, there can be good argument to seek to ring fence them and keep them outside of the matrimonial pot, so not treated in the same way for division, but it is still considered a resource, and importantly, it is available to meet needs. So if the matrimonial assets aren't sufficient to meet needs, then the non-matrimonial assets are more than likely going to be considered. Can you go on to the next slide, please? Now, the court is looking for a fair outcome. Now, as I've mentioned, all the circumstances of the case need to be considered. Above all else, the needs of the children are considered to be paramount. It is only after we've taken that into account that we then look at both of the spouse's needs, their income and earning capacity, any physical or mental disability of the parties, so the spouses, their resources, their ages and the length of the marriage, conduct, if that would be inequitable to disregard, standard of living, contributions, both during the marriage and anticipated in future, and any benefits that have been lost as a result of the divorce. Could you change slides, please? Now, in the event that the court is being asked to make orders for the benefit of a child, the court must also take into account the financial needs of the child, the income, earning capacity, property and other resources of the child, any physical or mental disability of the child, the manner in which the child is expected to be educated or trained, as well as the party's incomes, needs, standard of living and own health. Now, I mentioned earlier that there are restrictions on orders being made for the benefit of a child. And in this respect, it is really important to understand that the court is prevented from making orders in relation for a child above the age of 18, unless the child is or would be if an order was made in education or training, or there are special circumstances which justify the making of an order. Now, the special circumstances which justify the making of that order might well include where a child has got additional needs and there is a need for and dependence on the parents beyond the age of 18. Could you change? Now, the other thing that needs to be considered is the position in relation to child maintenance. Now, ordinarily, child maintenance can be addressed either by agreement or if it cannot be agreed, then in the first instance, an application needs to be made to the Child Maintenance Service. Now, the statutory provisions in relation to child maintenance are set out in the Child Support Act. Now, this sets out an obligation to both parents to maintain a child. It allows either parent to apply for a maintenance calculation to determine the amount that the non-resident parent should pay the resident parent for the maintenance of the child. It is a set formula which takes into account gross income, relevant other children, the number of children for which maintenance is being paid, and the arrangements for shared care. Could you change slides, please? Now, because the starting position is for child maintenance to be dealt with through this Child Maintenance Service or by agreement, there are restrictions which mean that the court is not allowed and not able to make child maintenance orders except in limited circumstances. Now, the powers of the court are such that they can make orders for child maintenance where it is top-up maintenance, where the non-resident parent earns in excess of the maximum income for the purpose of this child maintenance calculation. That does still require a maximum calculation to be undertaken by the Child Maintenance Service before an application can be made to the court. The other possibility is an application to the court for expenses connected with the education and training of a child, and of course that may well be relevant where you have a child with additional needs because there are costs associated with that which might not be covered by the local authority. If there are expenses attributable to the child's disability as a result of them being blind, deaf, dumb, or substantially and permanently handicapped by illness, injury, mental disorder, or cognitive congenital deformity, then that can also form a basis for an application to the court for child maintenance beyond the Child Maintenance Service liability. The other situation where a court is able to make an order is if both parents agree that a child maintenance order should be made. However, again, it's really important to keep in mind that where a child maintenance order is made by consent after a year, either parent can opt out and then an application is made to the Child Maintenance Service. Could you change slides, please? Now, what we've been looking at just now is very much in relation to the situation for parents who are divorcing. The situation in relation to unmarried parents is very different. Child maintenance is very similar in that you can reach an agreement or it's an application to the Child Maintenance Service. The key piece of legislation that we deal with when looking at claims for children in relation to unmarried parents is called Schedule 1 of the Children Act. Now, this allows applications to be made by a parent, guardian, special guardian, or any person named in a child arrangements order as a person with whom the child lives to apply to the court for an order for lump sums, settlement of property for the benefit of a child, to transfer property for the benefit of any child, and maintenance, but again, subject to the restrictions that we've already discussed. Now, a child over the 18 is able to seek maintenance and lump sum orders under this Act if they are or would be if an order was made in education or training, or there are special circumstances which justify the making of an order. However, this isn't available if there is a maintenance order in place immediately before their 16th birthday. Could you change slides, please? Now, there are some key considerations when we're looking at claims under Schedule 1 of the Children Act in relation to unmarried parents. That is that if property is settled or transferred, it will generally always go back to the other parent once the child reaches their majority or some other date agreed or ordered by the court. And the duration of the orders is until 18, unless there are, or would be, if an order was made in education or training, or there are special circumstances such as disability which justify a longer period. Could you move on, please? Now, in terms of why Burkitt Long, our family solicitors are specialists and were repeatedly recognised in the top as a top tier team in the Legal 500. We all have the experience and skill that you need to ensure the best possible outcome, together with the empathy and desire to help resolve issues in a way which preserves yours and your family's dignity, avoids inflaming the situation and keeps your costs to a minimum. Obviously, we have the benefit in having both a specialised education team as well as the family team, and that allows us to offer a depth of experience and expertise that many other firms cannot provide. Kimberley and I are able to discuss issues as needed if there is a crossover, so you can be sure that you are getting the best possible advice to your circumstances. We are able to offer in-person appointments at our offices in Colchester, Chelmsford and Basildon, but also we can offer telephone and video appointments if preferred. It's also important to highlight that we offer free initial 15-minute no-obligation chats for all potential clients who'd like to know more about how we can help, and you will have our contact details should you wish to pursue that option. Now, our top tips and resources. So, in terms of my top tips and resources, I would consider that communication is absolutely key. I appreciate it can be extremely difficult and is often not reciprocated, but when you are communicating, try and ensure that it is constructive, respectful and child focused. Concentrate on resolving issues rather than placing blame. Where that is difficult, there are parenting apps such as Our Family Wizard, which are really helpful. The Our Family Wizard app in particular includes facilities which allow for scheduling so that both parents can be aware of appointments and issues arising. It also has a language moderator, so when you are messaging through the app, if there is difficulty in ensuring that communication is respectful and constructive, it can aid the language by giving some hints and tips as to what you might want to say or might not want to say. The other thing that I would certainly recommend would be the Resolution Parenting Through Separation Guide, which should be available on the internet, but which, if anyone wanted to contact me, I would be happy to share. I think Kimberley also has a few tips for you as well.
Yep, thank you, Karen. So the education team are really proud to host a Facebook group where parents can feel free to ask our education solicitors questions, and we try our best to answer these as much as possible. And also it's a bit of a community where parents also provide their experiences and try to answer questions as well. We use this as a great way to give free educational advice, but also to signpost to what services that can be found. You can find the Facebook group by searching Burkitt Long Solicitors, EHCP and Send Law Advice Group. We also have a dedicated Twitter page to flag up any key cases or legislation that you might want to follow. And also we have a monthly question and answer session, which is similar to this in that it's hosted on Teams, and again, another opportunity for parents to ask our education solicitors any questions of a general nature, and we do a variety of webinars. Next slide, please. So before we take any questions, I just wanted to flag that we will be sending a recording round to everyone that has signed up today's webinar tomorrow morning. We'll also include a link to a very short feedback survey. We'd really appreciate if you could complete that, so we can make sure our future webinars are helpful to you. As we said at the start, this is one in a series of Wednesday webinars. Our next webinar is about an introduction to military law, and this is on the 8th of February. If you're interested in our future webinars, please visit our website, birketlong.co.uk/events, or our Eventbrite page to be able to sign up. And now for some questions.
Thank you, Kimberley. We've had a number of questions, and I think the majority of them are actually for Karen, but we have got one for you. So if we do that one first.
Yep.
Okay, that is it's from Anonymous. My ex-partner did not agree that our SEND child should transition to a special school when he left primary. I named a special school on the EHCP. Somehow he also named a school, but a mainstream school. His reason: my son is not one of those kids, in quote marks. Our son was placed at a mainstream, and after one term is really struggling emotionally, academically and socially. How and who should I approach regarding reassessing his needs and the suitability of the placement?
Right, okay, so in that situation, it must be remembered that the EHCP is a local authority document, so it's the local authority's responsibility to ensure that the EHCP is reflective of your child's needs and the provision required. So if there's been a lack of progress or there's concerns, the first starting point would be to contact your local authority to see whether the EHCP needs either an emergency review or its annual review, because an EHCP should be reviewed at least annually. So if there is concerns about your son struggling, you may want to consider whether calling for a review is necessary. In terms of assessing suitability of placement, that would be done at the review, and you would be putting forward your concerns about the current placement to the local authority, and why that's not suitable.
Great, thank you, Kimberley. And the next questions are all for Karen, actually. We've got about 7 minutes left, Karen, a few questions. Okay, the first one is on financial disclosure outside 12 months prior to proceedings. If their partner is moving assets prior to the divorce being filed, what can they do now and later?
Okay, so the 12 months generally relates to the general approach that we take to financial disclosure. Obviously, when you're going through divorce proceedings, both parties are under obligation to provide full and frank disclosure. And to support that, we would generally ask for 12 months bank statements, etc. Now, where there is concern that monies are being moved, our advice would be to get on with dealing with financial disclosure, ideally voluntarily, or if that is not going to be done voluntarily, that can be a good reason to look at having to make an application to the court sooner rather than later, so that that financial disclosure can be mandated. Now, where the moving around of assets has happened longer than 12 months ago, then that can be very tricky if you have information regarding assets that you know were held previously and there is no sign of them now. Then we can use the disclosure process by asking questions in relation to those assets specifically, but also where assets are being moved around, we can be looking at the disclosure that has been provided. We do go through it when we are going through that disclosure process with a very fine-tooth comb in order to see whether or not there is any evidence of assets being moved around. And hopefully that would answer your question.
Thank you, Karen. The next question is, what support for SEND children is possible in divorce once they reach 16 years and the main carer cannot work due to the child's varying needs? Is spousal support and children's support, especially costs for legal assistance, ongoing for potential risk of tribunal and annual reviews, etc.?
Okay, so so if you are going through divorce proceedings and the financial issues relating to that, then those future needs post 16 are something that should be taken into account when looking at the financial situation now. One of the things that we said would need to be taken into account was needs, both in terms of the children's needs and also the parents' needs. And also contributions are going to be relevant. Now, contributions don't only include financial contributions, but there's also contributions being made in providing those childcare responsibilities, and that does have an impact in terms of earning capacity sometimes. And if that is the case, then that is something that should be taken into account in ensuring a suitable split of the matrimonial assets. It could also be relevant when looking at whether or not spousal maintenance is appropriate. Child maintenance to a degree, though, we would need to keep in mind the restrictions that are put in place and ensure that that was dealt with appropriately. I should also add, though, that it's whilst within the matrimonial proceedings, the court is under an obligation to consider something called a clean break. That is very much focusing upon the claims between the parents, the spouses. It is never possible to what we call clean break a child's needs. So their ability or the ability to make applications on behalf of the children would still remain. The other issue in relation to the costs of legal assistance, I think that would just need to be taken into account from a family perspective as part of income and needs. But I appreciate that that can be very difficult to quantify when it's not necessarily known what they might be.
Thank you, Karen. The next question is, if you as the main carer make all the decisions for health and education as your partner chooses not to, in divorce both have 50-50 parental rights, but I'm worried that I will need to seek former spouse's consent to make education and health access, i.e. reports for the SENDist, AR or health assessments. The partner is likely to dismiss and not engage to be obstructive, hence they're worried that this will impact on timely decisions for the child. Is there a solution to this concern in DV? She doesn't want to restrict rights, but the partner has no clue and is unable to make and support the decision. And together, they've been able to bypass this behaviour, but once separated, third parties seek consent for both parents. So they're concerned that he'll be obstructive and continue to be obstructive.
Okay, so my advice in that situation would be to try and address issues by agreement. Obviously, if there are domestic violence issues, then that can cause some difficulty. In terms of the support that might be available from a domestic abuse perspective, when we're looking at domestic abuse, we're generally looking at application for things such as non-molestation orders and occupation orders. So a non-molestation order is an order which says that somebody is not allowed to use or threaten violence, harass, intimidate or pester the other. I don't think that that would be particularly useful in this situation when the decisions are with regards to the child. What I think would be relevant here is that if you do find that they are obstructive, an application can be made to the court for a specific issue order, and it may be that the court would be able to give permission for the decisions to be made by one parent if you know, the concerns can be made out that the other parent is being obstructive and not acting in the child's best interests.
Thanks, Karen. And the last question, we're just running out of time, is would non-matrimonial assets only relate to a parent if you have been married?
So non-matrimonial assets, that is a term that we use when we are talking about couples that are married and are getting divorced. When we're looking at assets who, with regards to claims between couples that are not married but are separating, all assets are taken into account. You know, we're looking at needs anyway, so hopefully that answers that question.
Thank you, Karen. That's actually all the questions. I think we're going to hand over back to Kimberley now to close this evening's webinar.
Yes, thank you all for joining us today. If there's any outstanding questions that haven't been answered, we'll contact you, but here is our contact details, which is on the screen currently, as to how to get in touch with us. So I'm Kimberley Hircock, and that's my email address, kimberley.hircock@becketlong.co.uk, and Karen Johnson's email address is karen.johnson@becketlong.co.uk, and there are our direct numbers. Thank you again for attending and have a good evening.